for standing down of employees in certain circumstances where there was a stoppage of work, where the employee couldn't usefully be employed within the employment business, and where it was reasonably unforeseeable as far as the employer was concerned. In those circumstances, before this legislation was passed, there could be stand downs. But this legislation changed things radically and provided much more flexibility in terms of dealing with employment issues at this time. The Fair Work Act was amended to support the introduction of the JobKeeper scheme on the 20th of March, and applications for job seeker and job keeper commence as of today and must be in by the 30th of April for payments in respect of April for employees. Significantly, this is only temporary, and the scheme ends on the 28th of September this year. That's not to say that it may not be extended, but the 28th of September is the date specified as the end date. And the changes are also being made and sought to provide for more flexibilities within awards under the legislation. Now, what happens is that qualifying employers, principally, are able to give directions to employees, reducing their hours or days of work, what we call the stand down directions. They can reduce the employee's hours or days of work, change the employee's usual duties, and change an employee's place of work. Such employers may also agree with employees for changes in days and times without reduction, and for accrued leave to be taken, or for double leave to be taken on half pay. We'll come to that a bit later on. Only certain employers can give directions. Qualifying employers must be national system employers who qualify for the JobKeeper scheme and are entitled to JobKeeper payments for the employee to whom the direction is given. Now, the JobKeeper payments are $1,500 per fortnight pre-tax, and the employer must pay the employee and be reimbursed by the government. As to those employers who qualify, the employer must have had a decline in turnover of 30% if the turnover of the business is less than $1 billion, or 50% if the turnover of the business is more than $1 million. And the employer must employ at least one eligible employee as at the 1st of March 2020. Employers significantly also include sole traders, directors and shareholders not employed but actively involved in the business. Now, payment can be made for only one of them, but their employees can also be included. Now, certain employees are eligible. Employees who are eligible for job seeker payments are those who, Andrew, I think you're a slide behind me, are employees who are at least 16 years of age and an Australian resident, who are not receiving government, parental or like pay, who are permanent part-time or long-term casual, and that means employees employed over a regular and systematic basis over 12 months. And those not otherwise totally incapacitated or on workers' compensation or who are not otherwise employed. In relation to directions enabling reduced hours, qualifying employers can direct an employee to not work on days the employee would normally work, to work for a lesser period on a day an employee would normally work, or to work a reduced number of hours. An employer cannot unreasonably refuse an employee's request to work a second job or to train whilst they're receiving these job seeker payments or subject to the JobKeeper scheme. The employer, in order to, so in terms of the prerequisites, the employer must qualify for the JobKeeper for that employee when the direction is given. The employee cannot be usefully employed for normal hours due to the COVID-19 crisis. That's a criterion. And the implementation of the direction must be safe. In other words, the employee, if they're going to be working at home, must be a safe environment. And the direction does not apply if the employee is on authorised paid or unpaid leave already. The employer must give written notice of the direction, which must be given 3 days or such other time as is agreed with the employee, and must consult with the employee about the direction before it is given. Now, there's a minimum payment guarantee associated with this. The employee is entitled to the greater of the $1,500 per fortnight pre-tax, or the amount payable in respect of the hours worked, including incentive-based payments, loadings, overtime and penalty payments and leave payments. So the scheme cannot be used to take advantage of employees in that way. There is also an hourly rate of pay guarantee. Employees' base rate of pay must be no less than the amount paid before the direction, so as the higher of the rate being received when the direction is given and the rate applicable to the duties being performed. The base rate is the rate payable for ordinary hours without additional penalties, loadings or additional allowances, loadings or penalties. Significantly, leave entitlements accrue as though the direction is not given, so the employee is considered to be working even though they're not doing so, and this does not affect their entitlement to redundancy pay or notice, so that their entitlement to that continues to accrue and they're given credit for the period of time they're subject to direction. Employers can also direct an employee to change their usual duties. The changed duties must be within the employee's skill and competence. The employee must have the required licenses, qualifications to perform the new duties and the like, and the duties must be within the usual scope of the employer's business operations. And it must be safe for the employee to perform them, and the employer must be entitled to JobKeeper payments for it. There are also rules in relation to directions. Sorry, I'm talking also the other aspect of the legislation is the direction to change location. Employees can be requested to change their location, including working from home, but the location must be suitable and safe, and bear in mind that the home is a workplace and therefore subject to the occupational health and safety requirements. The employee must not be required to travel too far, and performance at the location must be within the scope of the employer's normal operations. The employer is entitled to JobKeeper payments for it. As well as these directions that can be given, the other qualification about directions is they do not apply if it's not unreasonable, and the employer must believe the direction is necessary to retain one or more employees significantly. And that's got to be a considered decision on the part of the employer, and it's got to be on reasonable grounds, and the employer can be examined about that. It can't be just used at will. The employer must give written notice of the direction 3 days in advance or such other time as the employee agrees, and must consult with the employee about the direction before giving it. Agreements, as well as directions that can be given, agreements can be made in relation to certain elements, and in particular in relation to days and times. Qualifying employers entitled to job seeker payments for a particular employee can request the employee to work on different days, to work at different times than ordinary hours, as long as, and this applies when the change does not involve reduction in the number of hours worked, and the employee must not unreasonably refuse. There are prerequisites for these sorts of agreements. the performance of the duties must be safe, the duties must be reasonably within the scope of the employer's business, and the agreement must be recorded in writing. Now, another agreement that can be made is an agreement in relation to leave. Qualifying employers can request employees to take paid annual leave as long as they leave at least 2 weeks up their sleeves, or to take twice their leave at half pay. Now, an employee cannot unreasonably refuse the request to take annual leave. Doesn't necessarily apply to taking twice the leave at half pay. The agreement must be recorded in writing, and the leave and again, during this period of time, the leave continues to accrue, notwithstanding the new arrangements, and the period under subject to the new arrangements is included for purposes of calculation of redundancy and notice entitlements. Now, as well as these changes that have been made, changes are being made to 99 awards, inserting a new temporary schedule, including 2 weeks unpaid pandemic leave and the ability to take twice the annual leave at half pay, which is what we've discussed before. The awards are just being amended to reflect that. As I say, 99 awards, and I've given you examples there of some of the awards to which they apply, but you can see that it's far and wide. Now, pandemic leave is available to employees prevented from working due to either being required to isolate by the government or medical authorities, or due to government measures in response to the pandemic, closing down, requiring them to stay at home and the like. Significantly, as I said, the leave is unpaid. It is available in full immediately to full-time, part-time and casual employees. They need not wait for that leave to accrue. All eligible employees are entitled to 2 weeks. Paid leave does not have to be used before it's available or used, taken. The leave must be started before the 30th of June. And again, it does not affect other leave and counts as service for the purpose of accrual for redundancy and notice. Now, importantly, in all the context of these things, these changes are giving rights to employees, and these are workplace rights that, if transgressed, will see the employer perhaps on the end of a claim for adverse action on the basis that, or a general protections claim on the basis that the employee's rights have been abused. So it's very important. We all know adverse actions claims can be significant, and it's very important to ensure that employers are careful to comply with the requirements of this legislation and don't stand on the employee's toes. Obviously, the best thing to do in these circumstances, wherever possible, is to come to agreement with the employee so that there can be, and to evidence that agreement in writing. And finally, in dealing with employees, most of us are working from home these days, and in dealing with employees who are working from home, it's worth remembering that before requesting an employee to work from home, the employer should consider the terms of an employment contract, policy, award or enterprise agreement that applies. And home must be safe because it's covered by the occupational health and safety laws. If there's any doubt about that, significant, it might be worth having a visit or having somebody visit to ensure that's the case. Employees can be required to continue recording their hours if they were doing that beforehand, because employees are still obliged to comply with reasonable lawful directions of employers. And it might be reasonable for employers to add other requirements of employees to ensure that they're fulfilling their workload and they're applying themselves during the required hours. So that's all I've got to say on the employment issues. And I'll hand over to Sarah Ward, who's an accredited specialist in commercial tenancy law, to deal with the issues arising in the leasing field. Thank you.
Hi, Steve.
Thanks, Steve.
Andrew here again. We just had one query come through, which I think you might be able to answer very quickly, which is, can you request employees to take unpaid leave, even if they have annual leave available?
You can request them, but there's no obligation on them to take it. Unless it's included in your employment contract, there's no right to do so.
Thanks, Steve. Good morning, everybody, and thank you for joining us. I'm going to talk to you about negotiating your lease agreement pursuant to the National Cabinet Mandatory Code of Conduct. Now, the first place to start, whether or not the code applies to your lease, and I'll go through that soon, you should check that your lease terms first. Each lease will be different and include details of your particular circumstances and what was able to be negotiated when the lease was entered into. You should be clear on what your rights and obligations are, because it is these rights and obligations that will form the basis of any lease negotiations. In my experience, your lease is probably silent on how to, as in it won't specifically deal with a pandemic situation. However, there may be some clauses that assist in suspending these lease obligations, including a force majeure clause or rent abatement clauses. There's also been a suggestion that the common law doctrine of frustration may apply and may be available to end a lease. Now, I don't really have time to go through this with you, but if you'd like to know more, Steve, who you've just heard from, has an excellent article on the Aitken Partners website, together with some articles I have written and my colleagues, articles that relate to the COVID-19 pandemic and some of the legal issues that have come up. So first of all, I'll start with what is the code. So the code is a mandatory code that will be legislated by each state and territory. It imposes a set of good faith principles that apply to negotiating amendments to existing commercial tenancy lease arrangements during the COVID-19 pandemic. It's really all about sharing the impact to balance the interests between the landlords and tenants and sharing the financial pain proportionately. So how long will the code last?
Hello, sorry about that. It looks like Sarah has dropped out. Obviously, the world is having very tough times with the internet at the moment, so I'll just try to get Sarah back online. She may not be aware yet. But in the meantime, I have one more question come through, Steve, which you might be able to answer while we're waiting for Sarah. And that is where an employee is a part-time employee, is paid less than the JobKeeper payments, for example, 2 days a week at $1,000 a fortnight. If you have work for them, can you request that they work the 3 days a week to take them up to $1,500?
Good question. I think the agreement is that they only work 2 days a week. I don't think you can require them to work 3 days a week. And of course, obviously, it's advisable to come to an agreement about that sort of thing, but I don't think there's any entitlement to require them to work longer.
Okay. I'm still trying to track down Sarah, so depending on how we go, we might come back to Sarah in a few minutes, and I'll just flick us through, and we might start with Chong, Quaik, to talk about migration while while we're waiting for Sarah to come back online, and I'll jump off and ask her. So I'll hand over to Chong and come back to Sarah in a couple of minutes. Chong.
Yeah. Thank you, Andrew. Good morning, everybody. Let's go straight into the my slide. Okay. Can I have my slide up, please?
Yep, getting there, Chong.
Okay. Thank you. We're going to look at the outline changes to the migration law and policies affecting the temporary visa holders. We are going to leave out Australian permanent residents and citizens here due to the time constraint. We are going to focus on 4 main visa subclasses that I believe will be relevant here. Number 1 is the new COVID-19 visa subclass 408. 2, visitors visa. 3, international students visa. 4, temporary work visa, or commonly known as 457 visas, and now it's 482 visas, plus the inbound travel ban to Australia. Now, let's start with COVID-19 visa. It's a visa that was introduced on the 4th of April this year. The visa is called Temporary Activity Australian Government Endorsed Event Stream Visa. Basically, what happened is that government classified COVID-19 pandemic as an event, and therefore it fits into the subclass 408, Australian Government Endorsed Event Stream Visa. The purposes of this visa is to provide a pathway for eligible temporary visa holders who were required or supposed to depart Australia, but for the COVID-19 pandemic, unable to depart Australia. The visa is also to implement a measure to respond to workforce shortages during the COVID-19 pandemic in relation to critical areas, including agriculture, childcare, disability care, aged care, and public health, and also food processing. COVID-19 pandemic was defined as the pandemic declared by the World Health Organization on the 11th of March, caused by the coronavirus COVID-19. The main requirements for this visa are the person must be physically in Australia onshore, unable to depart Australia because of the COVID-19 pandemic, work in the critical sectors, including agriculture, aged care, childcare, public health, food processing, unable to apply for any other temporary visa, and can only apply within 28 days before or after the visa expiry of the current visa. Is this the visa of the last resort? It appears to be so. Last resort to deal with the temporary visa holders who are in Australia. If you look at the 3 main criteria, that is, worked in critical sectors, unable to apply for other temporary visas, and can only apply within 28 days before visa expiry, or 28 days of becoming unlawful. If you look at these 3 main criteria, it will limit the scopes of application. So I do not believe that it's going to have a wide range of application, that not wide range of people can qualify or be eligible under this COVID-19 visa. The cost is free of charge, but let's look at this other classes of visa that may not have COVID-19 visa applicable to them. Number 1 is the visitor visa. The message from the Australian government is clear. If you can, depart Australia before your visitor visa expires. If you cannot depart as planned due to travel restriction, not able to find a flight, not safe to return to the country of origin, then you must apply for a new visa before expiry of your current visa. However, if your visitor visa has a no further stay condition, or more commonly known as 8503, 8534, 8535 condition, you must request a waiver of this condition before you can lodge a new visitor visa application. This is a bit like the caveat in property. So no further stay. So you must get the caveat removed before we can deal with the your current visa. Now, what are the grounds for the waiver of no further stay? The grounds are that since the grant of your visitor visa, compassionate or compelling circumstances have developed, and these circumstances have resulted in a major change to your circumstances. So you can see that it's not difficult to argue that COVID-19 pandemic is a compassionate and compelling circumstances that have developed beyond your control since you were granted the visitor visa. So I believe that COVID-19 pandemic will be a good ground for you to get rid of the no further stay condition before lodging an application to have a new visitor visa to continue to remain in Australia. Given the queue, it's advisable to apply 2 months before your visa expiry. I believe that at the moment, the Department of Home Affairs is adopting a pretty sympathetic approach on this. Next, we're dealing with international students. International students are expected to rely on family support, part-time work where available, and their own savings to sustain themselves in Australia. So in general, there's a work limitations imposed on student visas. International students are permitted to work up to 40 hours per fortnight during study when a course is in session. Can I have next slide, please, Andrew? However, the government now relaxed this working hours limitation of 40 hours per fortnight for students who are enrolled in a nursing course and can undertake work to support healthcare as directed by health officers, or the student has been employed since 1st of March 2020 in the aged care sector or by registered major supermarkets, including Aldi, Coles, and Woolies. However, this relaxation of working hours limitation will be terminated from the 1st of May this year for supermarkets. Now, for those students who are in financial hardship, what concessions are given to them? In their student visa application, international students must demonstrate that they can support themselves completely during their first year in Australia. So only holders of student visas who have been here for 12 months or more, who are unable to meet immediate living expenses, can apply to access up to $10,000 of their Australian super in this financial year. But they must do so by the 24th of September this year. The other concessions that the government has given to overseas students are the government will be flexible in cases where COVID-19 pandemic has prevented international students from complying with their visa conditions, example, meeting course requirements or not being able to attend classes. Now, the next subclass we're going to discuss is work permits. Subclass 457, the popular subclass 457, and now it's called 482, subclass 482. The Department of Home Affairs has indicated that subclasses 457 and 482 visas are given concessions. Sponsors will be able to reduce working hours of the sponsored employee without them breaching their obligations. And employees can be stood down and not be in breach of their visa condition. In a nutshell, what happened in this case is this. The government has given the employers and employees of the 457 visas the concession to play around with working hours. So they can do it to reduce the hours from full-time to part-time, or all the way reduced to 0 hour, which means standing down, right? So to reduce working hours from full-time to part-time, like I just mentioned, provided the pro rata hour rate of the approved salary as per the nomination does not decrease, and the role and duties performed remain as per the nominated occupation. However, the employees who are working part-time now are not able to access superannuation. For those who have been stood down, they are still considered to continue to be under the employment of the sponsor or employer, notwithstanding they are not going to work or getting a salary. So if stood down, they can apply to access a superannuation up to $10,000 this financial year. Again, they have to do so by the 24th of September this year. Layoff. It is not allowed under migration law for workers, employees to be laid off or to have their employment terminated without breaching the visa conditions. If an employee is sacked, he or she must find another sponsor and lodge a new nomination or apply for another visa, for example, student visa, trainee visa, or partner visa, or depart Australia within 60 days. The sponsor is obligated to pay reasonable travel costs for the employee and family, or if the employee has disappeared into the community, has gone under, the cost of locating the employee and sending them back will be borne by the employer. So be careful, you want to terminate your workers under 457. Moving forward, it's predicted that it will be more difficult to be granted work visa, with the exception of nursing and medical. And the reason is very simple. Many local Australian citizens and permanent residents have lost or will be losing their jobs due to the COVID-19. And therefore, there will be more Australians who are able to fill the vacancies. So it will be hard-pressed to show to the Department of Home Affairs that once you advertise the labour market testing test, you are not able to find a suitable employee to do the job, and you have to rely on foreign nationals to fill the job. Next slide, please. Thanks, Andrew. Can the employer reduce salary? The answer is no. Even if both the employer and employee agree, they still need to apply for a new nomination and new visa application, provided that the salary is still the market rate and above the threshold of $53,900 per annum. Like I just mentioned, it will be hard to pass the labour market testing. Moreover, the new application will attract an additional Skiing Australia fund levy. At the moment, is $1,200 per year if your business turnover is less than $10 million per annum. Next slide, please. Can the employee perform work outside the normative occupation within the business? The answer is no. There will be clear breach of conditions 8107 and 8607. The visa holders are limited to working only in their nominated occupations. Sponsors are in breach of their obligations for failing to ensure workers to work only in their nominated occupation. If employer is found doing so, they will be subject to sanctions to sponsor employees in the future. If an employee was sent overseas to work and is stranded there, is that a breach of the visa condition? It may not constitute a breach of visa conditions if the duties of the employee include overseas travel. For example, those of the import-export manager, international marketing manager, and the nature of the work is possible for the work to be done remotely. But a better solution is to apply for exemption for him or her to return to Australia despite the current travel ban. Now, let's look at the travel ban. Australia has closed its borders to all citizens and non-permanent residents. The entry bans takes effect from 20th of March 2020, with the exemptions only for Australian citizens, permanent residents, and immediate family members, namely the spouses, dependent children, and legal guardians. The immediate family members who have a visa must complete a form for COVID-19 inquiry form online and apply for approval before traveling to Australia. Exemption to travel to Australia. Travelers who have a compassionate or compelling reason to travel to Australia will need to have an exemption from the Australian Border Force Commissioner before they can travel to Australia. The ABF Commissioner may consider an additional exemption in relation to the travel ban for the following classes: foreign guests invited by the Australian government to assist in the COVID-19 response, critical medical services including air ambulance, people with critical skills, for example, medical specialists, engineers, and so on, and case-by-case exceptions for humanitarian or compassionate requests. Now, all travellers arriving in Australia must undergo a mandatory 14-day quarantine at designated facilities, example in a hotel in the airport of arrival. This includes temporary visa holders who are granted exemptions by the ABF Commissioner. In a nutshell, that's all from me in relation to migration issues arising from COVID-19 pandemic. Thank you.
Hi everyone, sorry about that. I believe that I was up to the duration of the code. So the code says it will commence on a date that's after 3rd of April 2020 and will last for a period that the JobKeeper program remains operational. This is currently until the 27th of September. However, this might be extended. So who does it apply to? The code applies to small and medium-sized businesses, and there are some criteria that a tenant must meet for the code to apply. These are Number one, the tenant must be suffering financial stress or hardship as a result of the coronavirus pandemic. Now, it's worth noting that if the tenant is eligible for the JobKeeper payments, they are automatically eligible. And secondly, the tenant must have an annual turnover of up to 50 million. Now, these tenants are called SME tenants in the code. The $50 million turnover will apply to franchisees at a franchisee level, but to a company-owned retail store at a group level, not on an individual store level. So what exactly is the code? The code includes overarching principles that recognise that landlords and tenants share a common interest of working together and to keep leases on foot after the end of the pandemic. Landlords and tenants are required to negotiate temporary leasing arrangements, and that these negotiations should be open, honest and transparent, and the parties should negotiate in good faith. Now, all leases will be negotiated on a case-by-case basis, as everyone's circumstances are different. The code also contains a set of 14 leasing principles that should be applied in negotiating and enacting temporary lease arrangements. Now, I've summarised these. The whole 14 can be viewed in the code itself. But first of all, some of the landlord's rights are restricted under the code. For example, the termination for non-payment of rent is prohibited. This is during the pandemic period and a reasonable recovery period. There's no fees, interest or other charges applied to waived or deferred rent, and you can't use security for the non-payment of rent. Now, landlords must also offer tenant some things. This includes a proportionate rent reduction in the form of a waiver or deferral. These reductions are based on the reduction of the tenant's trade during the pandemic period plus a reasonable recovery period. Any reduction of statutory charges and insurance must be passed on to the tenant. Now, any deferred payments needs to be given a minimum of 2 years to repay, or the length of the lease, whichever is greater. And this repayment would not commence until the earlier of the lease pandemic, the end of the pandemic, or the end of the lease. An opportunity to extend the lease by the period of rent waiver or deferral period must also be offered to the tenant. And there's a freeze on rent increases, with the exception of retail leases which are based on turnover rent for the pandemic period plus the recovery period. Now, other benefits received by the landlord should also be shared. For example, if they have relief from loan payments. And if they can, they should waive other expenses, including outgoings. Now, the code refers to where appropriate. So again, on a case-by-case basis, whether other expenses will be waived. And there's to be no penalty for reducing hours or ceasing trade. Now, when we look at the tenant's obligations in the code, the tenant must remain committed to the terms of their lease, subject to the amendments that have been negotiated. Tenants will actually lose the protection of the code if they don't comply with the other terms of their lease. Now, there's no direction in the code about how this would work in practice. It may mean that the tenant will lose any benefits the landlord is obliged to give the tenant an additional relief that has been negotiated. Now, there's some criteria for the rent waivers or deferrals I spoke about. Rent waivers must be no less than 50% of the total reduction, and tenants can waive this requirement of the 50% reduction. It should be greater than 50% where the tenant would not be able to fulfil its obligations under the lease agreement, but regard should be given to the landlord's financial ability to do this. Now, there's an example given in the code, which is 60% of turnover equals 60% cash flow relief. A minimum of this 50% of cash flow relief will be a rent waiver, and the rest can be rent waiver or rent deferral by agreement. Now, this is an evolving situation, and the relief available has changed quite often. In Victoria, the code has currently not been incorporated into legislation, but it's anticipated that on the 23rd of April, the Victorian Parliament will sit and legislate for the reforms implemented by the code. The most recent update that I have is that on the 15th of April, the Victorian Government announced a commercial tenancy relief scheme that gives us some clue of what the legislation will contain. Now, the media release mentioned a temporary prohibition on commercial tenancy evictions for non-payment of rent, a freeze on rent increases for 6 months, rental waivers or deferrals proportionate to income reduction, and a mediation service for tenants and landlords to support fair tenancy negotiations. It was also announced that land tax relief will be provided to landlords that provide the tenants with this rent relief. Landlords may be eligible for a 25% reduction on the property's 2020 land tax. And for those commercial landlords to be eligible, the property must be rented to a tenant with an annual turnover of up to 50 million, and the tenant must be eligible for Commonwealth Government's JobKeeper payment. Now, I don't have a slide for this, but I did briefly want to touch on documenting your agreement. Now, it's very important that you record this agreement in writing. This can be either a deed or an agreement. You should note, however, an agreement might be the best way to document what you've negotiated with the landlord at this point, because it can be executed electronically. And this might be the safer and easier option given the social distancing requirements that we currently have. Now, lastly, what if you and your landlord can't agree? In this case, there's going to be a binding mediation service, and it's been suggested that the mediation process will be conducted by the Small Business Commissioner. Thank you.
Thanks for that, Sarah. We've got a couple of questions. So firstly, I'll do two that have come through to you. So one from Stuart, where he asks, where a lease has expired and the tenant is now on a monthly tenancy, what provisions apply?
So the code doesn't specifically mention anything about particular circumstances. It only goes so far as to say that everything needs to be looked at on a case-by-case basis. At the moment, that's the only direction we have. If we get some legislation in place from the 23rd, I hope it contains some more detail there.
The next question is from Carla, and she's asked, will rent increase freezes apply to all commercial tenants or only to those qualifying under JobKeeper?
So it's an interesting question. It's referred to the JobKeeper payment throughout the code. However, technically, I think if a tenant is in financial distress, and there is actually a definition given in the code, that they could technically be, the code protections could technically be available to them. However, I think that when you read the entire code, they need to earn less than $50 million, so that criteria still stands.
I think the important thing for people to understand is that there's not always a blanket rule, and sometimes you really just do need to jump on the phone and talk to someone like Sarah. The last question on property, or actually another one just popped through as well. Small business operating from an owner's property, is the owner obliged to reduce the rent paid by her business to herself in order to maintain the viability of the business?
That is a very good question. Look, I think at the moment we need to follow the code. So that would include a 50% rent deduction, provided that the tenant company is in financial distress and meets that criteria under the code.
And the last one, hopefully for you, is how to decide the percentage of turnover drop of a tenant's business, which period to compare, e.g. the last month, last quarter, or same month, quarter last year.
Yeah, look, and that's interesting because the code doesn't actually give us any direction there. However, when we look at how the JobKeeper payments are calculated, and you need to calculate loss of turnover there, the way that the JobKeeper is calculated is there's 3 ways. You can calculate the turnover from March 2020 with a turnover from March 2019, or you could calculate the projected turnover for April 2020 with that of April 2019, or you could even compare the quarters starting from April 2020 to April 2019. So at the moment, until we have any more direction, I'd be minded to go through the JobKeeper calculation.
Excellent, thanks for that. So Steve, we have a couple for you now. So Anthony Edwards is asking about JobKeeper payment for directors, shareholders and working directors. How many can be paid?
Only one, but also for employees. Can you hear me?
Yep, can hear you okay.
It's only one.
Excellent. Osk wants to know if the JobKeeper payments are available to contractors.
They just fall in the same position as normal, either incorporated entities or as the sole traders who are employed in their own business and who would be entitled, as set out in that paper, like the directors or the shareholders or the sole traders, to the JobKeeper scheme for one person as the employee, the contractor, and for any employees as well.
Okay, and one last question is from Linda, who's asking about protocols around long-term casual employees, and are you constrained by the average they may have worked up to that time?
They've got to have been employed over a period of 12 months on a regular and systematic basis. That's the criteria. Systematic means systematic, I guess. It's not ad hoc. It may well be ad hoc, but it's got to be pretty systematic ad hoc if that's not a contradiction in terms. So it'll probably depend upon all the circumstances in that particular instance.
Okay, thanks.
Just hold on. Somebody said I was referring to how many hours they worked. Well, I think if we're referring to a number of hours, the same would apply. If they're working a few number, can you use up the whole 1500? Again, it really probably depends on the circumstances. As long as they're employed on a regular and systematic basis, probably regardless of the hours, they're casual employees and therefore have the benefits of the JobKeeper scheme. Is the short answer.
Cool. Well, thanks for that, Steve. We'll have another webinar in a couple of weeks on solvency and insolvency issues. So how to balance out your cash flow requirements and a few other issues around that. So there'll be an invite going out for that shortly. I'll just remind you that the webinar is simply a webinar and not to rely on anything that anybody has told you as legal advice. So please make sure that you check with your lawyers or accountants if you need specific advice on certain parts of the legislation, how it's going to apply. And I think, as Sarah said, this is very much a moving feast. It's almost daily updates and certainly weekly updates as to what is and is not covered under the laws. So, please stay on top of it. We hope to have lots of articles up on our website to explain the different changes as they're coming through. And we'll try to communicate with you as regularly as we can. So thanks for joining this webinar and look forward to seeing you soon. Bye.